allow us
How,
to do so.
how much time do you need to study the legal opinion?
24 hours.
Okay.
But we have a preliminary view now, just on certain maybe 2 or 3 questionable issues that we see there, just so that you have an idea of why we have this position.
Let me hear you. What do you suggest?
No, just on the advice, for example, on when just skimming through the legal advice, our disagreement with the position, for example, in paragraph 21 on Honorable Shikling, although the advice correctly distinguishes between a permissible and mere disposition and a tentative view, it also cites a principle of bias or partiality that occurs when a tribunal approaches a case and it shuts its mind to submissions made or evidence tendered, close quote. The advice then further claims that being the complainant who opened the criminal case against a witness does not exhibit bias. We disagree on the basis that by opening a criminal case, the affected members have taken a definitive adversarial step of alleging the witness committed a crime and therefore initiating a process intended to lead to their prosecution. This is not a tentative view. It's not a general political
Honorable Sauls, let me stop you here. You see what the reason why I came with a proposal like that one is because I want us to have an approach. And let me suggest this to you, that this meeting notes and accepts that a legal opinion has been served from Parliament. And then the reason why we say members must take this legal opinion and go and study it is so that if you want to make a submission, the submission must then be made to the relevant legal section in Parliament. And then once they have received your submission, they will then go and look at it. And then from there, they will come and say to us, we request the committee to meet because we have received the following feedback. And we want to now explain to you how we're dealing with as the legal section of Parliament. Does that make sense?
No, it doesn't, Chair, because I'm not submitting a legal position. I'm stating what our view is on the advice. That's what I'm doing.
Yes, you have a different view from what is being presented.
Yes, so I'm not. It's not a legal thing that I'm giving. I'm not a lawyer. So as a political party, we are sharing with you.
That's exactly what I wanted to avoid. You know why I want to avoid that? You can imagine if all of us here give opinions like that. At the end of the day, we are going to expect somebody to give a summary of what the decision should be. And it will be...
Chair, I hear what you are saying, but what I'm trying to say is at least we should be able to share our view on the matter, despite what the House is going to decide. But at least you heard why we question the advice. And if the House decides to go with the legal advice, that's fine. But you should grant us an opportunity to say, on this particular matter, we disagree. We disagree that when you open a criminal case, that there's no bias. When you open a criminal case, you are saying that you believe the person is guilty. And so if you're going to sit on a committee, you are going to be perceived to be trying to get even more information to support that view. That's basically what we say. The same with the advice on Honorable Barnard. The advice says that she has a personal interest, which is correct, but then it limits the remedy to stating that she only needs to withdraw only when the ad hoc committee considers or decides an issue. But yet the argument, that argument assumes that the issues are neatly compartmentalized, which is not true. General Mkonazi is the key witness whose allegations sparked the entire inquiry. He has now publicly attacked a committee member, Honorable Barnard, calling her a criminal under oath in her capacity as an MP who previously disclosed information. So personal interest is not limited to the discussion of one paragraph here of the terms of reference. Her interest now extends to the entire credibility assessment of the primary witness. Mkonazi's credibility is central to every issue the committee considers, isn't it? So allowing Honorable Barnard to participate in assessing the overall truthfulness of the person who just accused her of a crime violates the spirit of fairness and rationality. And that's the points that we're trying to make here, to say we have a position. But if you say legally, man, it doesn't matter, fine, but at least we should, in this platform, be able to state for the record what our position is, whether you accept it or not. You know, and the advice that says that, and I raised it with you, Chair, that honorable members are not meant to be impartial or unbiased participants, you know, and their prior knowledge makes them effective committee members. You know, that advice, it conflates general political bias with personal conflict. Political bias, yes, is acceptable. A member voting on a policy because of their party opposes it. But personal conflict is unacceptable. A member sitting in judgment of the truthfulness of a witness who has just publicly accused that member of criminal conduct before a body. The advice uses the principle of political representation to justify a scenario of personal animosity. When Honorable Barnard questions, for example, if she had to question General Mkonazi, a reasonable person would have apprehended that her questions are designed to discredit her accuser and to protect her own reputation. The same applies to Honorable Breitenbach, whom the witness alleged that she has a hand in withdrawing a criminal case when she was at the NPA against Mr. Ndluli. Honorable Cameron, same thing. When he chaired the meeting on the 5th of March, Honorable Cameron used the committee as an opportunity to clear himself from the allegation that General Mkonazi made. That clearly showed a reasonable apprehension for bias. He displayed it. Plus, he insinuated there was nothing material said in the meeting that gave rise to what we are dealing with now. Yet, when we study the witness statement that the main witness has given to us, the minutes of the meeting on 5 March, what do we see? When you read what the minute says General Mkonazi said, it is the exact same things he said at the press briefing on the 6th of July. The exact same things. There's no difference. And then the main witness says that after that March 5 meeting, he felt that he's now exhausted all remedial mechanisms. He went everywhere and no one listened. And as a result, after the parliamentary meeting, he then said if Parliament is not going to do nothing, he's going to go to the television. And that's what he did. So that meeting played a key role in why we are where we are here now. But we're too afraid to say to Honorable Cameron, Honorable Breitenbach, and others, why? I'm not going to participate in the attempt to paint a picture that when we deal with corruption, it's always a blackface. And when you have to interrogate corruption, it's a full white team. Even when they had the opportunity to replace the person, there's no, DA has no non-white, black, colored, Indian, competent people to come and interrogate corruption. I'm not going to be a part of that. And neither am I going to be a part of an unfair process. So if the committee overrules me, that's fine, I'll accept it. But at least, chairperson, on the platform, we should be allowed to, in detail, state why we challenge the advice. Therefore, I'm asking, which date will this happen? Whether you accept it or not, Chair. But I'm not a lawyer. I don't have I don't need to give it to the legal team, and the legal team has to. I mean, that's a different process altogether. But just as a political party sharing our views, we should be granted an opportunity to do that. I did that briefly now, but the meeting that we're talking about, where we can in detail deliberate it, would be appreciated. But even if, Chair, you say, and the House decides that's not necessary, that's also fine. But at least we've put for the record that there are conflict. There is definite conflict, and that's our position. We disagree with the position of the House. Thank you, Chair.
Look, the difficulty that I have where I'm sitting here is how to respond to your arguments, because I think what I have proposed is to say, members, Parliament has given us a legal opinion, and the legal opinion is presented here in the meeting. We must note this and accept that there is a legal opinion and live with it. But then if members want to go and study this legal opinion, maybe even enrich it, what they will do is, for instance, what Honorable Sauls is saying, because this legal opinion is not coming from Honorable Ntuli or Honorable Breitenbach, Honorable Malema or Honorable Mwango. It's coming from Parliament. So if you have views on these legal opinions, after studying it, you must write down those views and send them to the legal team of Parliament, which has made a presentation here. And then the legal team will come and say, we presented a legal opinion in your meeting, and then the following members have given us feedback on the legal opinion that we presented. And then this is how we are clarifying their matters. I think that is the approach that we should take. But if we are going to make a presentation here, and Honorable Sauls, you also raise legal matters on top of the legal opinion that has been presented here, there is nobody who is going to be ready now to respond legally. Because if you raise something that is different from the legal opinion, it means the person who developed this opinion must go back and look at the arguments that you raise and come back and clarify them. So, and that is basically why I made the proposal that I made, to avoid a situation where we are going to sit in this meeting the whole night debating legal matters, and each one of us can have a legal view, than to say a legal opinion has been presented. For the conduct of the proceedings, we are going to follow these legal opinions. When members are studying it, if there are views that members have, those that want to make submissions directly to the legal section of Parliament, and they will come if they have considered that, to say, this is what we have received. I can see your hand is up, Chief Whip.
No, Chair, can I just respond to you because you're addressing me?
No, I'm not addressing. I'm addressing the meeting. I will come back to you. I have noted the Chief Whip.
Okay, sir.
No, thanks, Chair. Thanks, and good evening to you and all the colleagues, everyone who's on the meeting. Well, for me, I agree with your proposal. I think you are quite right that we should be given an opportunity to go through and internalize the parliamentary legal opinion. Because as much as we may not be in the position where we might decide that we disagree with it, and would be perfectly at liberty to state our views in that regard, even if that doesn't change the position. It doesn't mean that because we're members of parliament, we agree with everything that parliament says and does. There would be instances where we disagree. We've seen that in the past, and it's not going to be for the first time now. So I agree with your proposal that let's allow a bit of time, we go through this legal opinion. The second issue, I don't agree with us accepting the DA legal opinion in this meeting. I think we should ask Parliament, in the same way that we will be reflecting on our work, to equally reflect on the work that was done by the legal advisors of the Democratic Alliance, and then give an opinion on behalf of the institution. If we don't do that, we're likely to open a Pandora box where each of the parties who are here, whenever there is a particular view to be debated that has got to do with legal basis, we will all bring our own legal documents. And because we have accepted one that came first, we will have to accept the rest. So I think we should welcome the fact that the TA has made an effort to acquire legal opinion to guide them, not to guide the committee. And there's nothing wrong with them having done so. But I think we should allow Parliament to go through that legal opinion. I do want to, I understand very well where Honorable Sauls is coming from. And to a larger extent, I agree with him. I may not agree with him on the specific issues, but the principle that is addressing about who we are and how we should relate with matters of this nature is correct. And I want to suggest that without prolonging the debate on that issue, you afford us an opportunity at a later stage to discuss the issue. But at the moment, because tomorrow we have a witness, we take a principled decision that we will be guided by the parliamentary legal advice insofar as we do our work tomorrow and Friday. And hopefully before we proceed next week, you give us an opportunity to do two things. One, to get a parliamentary position or legal advice on the DA's legal opinion, on the matter relating to the DA's legal opinion. And secondly, to allow us to state our own views and positions about what we think is right and wrong in the context of what is before us, and then proceed from that understanding. So that's what I want to concretely suggest, Chair. Thanks.
Okay, Honorable Sauls.
Yeah, Chair, I wanted to say earlier that I take your guidance and to say that, but you should just know that I'm not going to submit a legal opinion. We can source such, but I don't deem it necessary. But I would like to enjoy the right as an MP on this committee to share my views, our views on what has been provided. And if it's just there for the record to be considered, that's fine, as long as we have stated our contrary view to the legal advice, because it's an opinion, and also the decision of the committee to follow through on that advice. We would just like to have on the record, these are the reasons why we question that advice, but we do not accept it. We disagree with it. So I can submit with it by tomorrow the views, and then it can be whatever the process is. And then, which now begs the question, Chair, if when I now submit in writing our reservations and our position, when would I then receive a response back? Because this to me seems like if we accept the advice, go study it, it's just buying time so that we don't talk about this issue and the committee continues. It's almost like a different way for it to continue. That's how it can be perceived. So therefore, I'm just looking for specific timeframes. I submit tomorrow. When do I get a formal reply back on what on what I have submitted? Thank you, Chair.
Okay. Honorable Vessels.
Thank you, Chairperson. I think your proposal is constructive. The fact of the matter is this whole issue will become moot at some extent, or to some extent, pertaining to this specific issue that this legal opinion was on. Obviously, there will be similar situations and might be similar situations of perceived conflict and bias. But I think the most important part is to have a decision and consistency before we proceed with the questions by members to the Honourable Mchunu, because the same issues will arise there. So if this is going to be revisited, it must be revisited before next week Tuesday, or we should now accept that we take this position as we did yesterday, because the legal opinion affirms the way in which we proceeded yesterday, where the Honourable Skosana was allowed to put questions to General Sibia, and we proceeded in that way, and the legal opinion affirms that it, according to that opinion, is correct. And if we proceed in that way and allow the Honourable Skosana to also put questions to the Honourable Mchunu, then it's fine. But I do think there should be consistency and clarity before we move on to next week Tuesday. Thank you, Chair.
Thank you. Honourable James.
Thank you so much, Chair. Action SA's stance was from a model and principled view. So we note the legal opinion, but we don't agree with it. I pretty much agree with Honourable Sauls and also with the Chief Whip. We've exhausted this topic, the situation, extensively, and I'm looking at this pattern here. In the first committee meeting, we said, let us wait for the DA and we'll get a response from the DA, and let us allow the DA to come back to us with their decision. We did that. The DA has now come back to us with a decision. We're now saying, let us allow for legal opinion. We've received the legal opinion. We are now saying, let us allow for parties to deliberate and maybe give their input on at which point are we actually going to take a decision on this matter. I'm also asking that we be given some time just to go through the docket, the document, the opinion, and then get back to you with our input. Thank you, Chair.
Okay. Andile, I'm going to give you to outline the procedure. You have presented a legal opinion here. Members who want to give you feedback, how do they do that?
Yeah, sorry, Chair. Chairperson, the opinion I've presented to this committee meeting, Chairperson, is the position of legal services. And Chairperson, of course, it's an opinion. I think members are entitled to differ with it, to engage with it. But Chairperson, those are called dry legal principles. It's not unless it's not something that is coming from my head, Chairperson. It's decisions of our court, Constitutional Court, Supreme Court of Appeal. And I think at this stage, Chairperson, I'm going to plead with members, perhaps to go back, and as you said, Chairperson, read them. But Chairperson, regarding the way forward, I think the the Chief Whip was correct in saying, Chairperson, members have a right, to differ with an opinion because it's an opinion, Chairperson. But Chairperson, there's really nothing more we can do because, as I said, it's not something that we're just extrapolating from thin air, Chairperson. It's legal principles. We've looked at law reports, we've looked at case law, and that's our view, Chairperson. And of course, the meeting is within, its powers, Chairperson, to accept or reject our opinion. Thanks, Chairperson.
No, yeah, I think what we should do here is that, like you say, that this is your position. It means you will not change as Parliament. Is that what you are saying?
Yes, Chairperson.
Yeah. So what we should do, honourable members, is that let's note and accept that there is a legal opinion. And if there are members here, like we said, who will want to go and study this legal opinion and make submissions, they will make those submissions to the legal team of Parliament and delays here to say, where I'm standing, I have read the following paragraphs, and maybe I have consulted. This is how I think I want to raise my concerns or the views that I have with regard to the specific paragraphs. And then the legal team of Parliament will come back to the committee and say, we have received submissions from the following members, and we have also consulted further. There is nothing that makes us to change the position that we have presented you, or on further consultation, we are persuaded to make amendments to the following. But for now, honourable members, in case there is anything that comes, we are going to deal with it in accordance with the opinion we have. Is that okay, honourable members?
Chair, may I?
Honourable Sauls.
Chair, I just want to just emphasize to the legal team of Parliament that the spirit with which we're doing this, it's not at all to point out anything towards their competency or not. We definitely believe that they are competent. We do take that they've put in the work and they've used their professional expertise to look at case law, etc. We don't have that expertise, and we do value that input. We are merely using this platform and the rights that we've been given to express ourselves and our opinion to do so in this instance. We are merely looking at the interpretation and how it is applied, and we still believe that there's a presence of bias, and we are merely just expressing our opinion in that way. Not at all to say that ours is superior, our opinion is superior to theirs, because theirs is on a specialized level, and we are not at all saying we consider that inferior, not at all. So I just wanted to stress so that our responses are received in the correct spirit, Chair.
Yeah.
Thank you.
Yeah. So in the submission that you will be making to them, you must then advance cause that shows that there is presence of bias, like you say, so that when they go to consider your submission, they must understand exactly what are the arguments that you are advancing, and the presence of bias, how is it demonstrable? And then when they have received that submission from you, because what we should avoid, if we sit in this meeting now and try to say there is presence of bias or there is no bias, I can tell you we will never agree. Like one member has said here that we who are not legal persons or who are not legal experts. We will never we can discuss this thing until the sun rises. And remember, this document which was presented here, it was also professionally prepared. Consultations were made until a compilation like this one is brought before us. So if there is any matter that has to be responded to, there is nobody who can respond to legal issues off the cuff. And they have to be systematically presented, and then the legal team considers them and comes back to the committee with a feedback. And so that is the opportunity which all of you members are being afforded.
Chair.
Hello, Honorable Malema.
Thanks, Chair. I think it's a given fact that when you call for a legal opinion and that legal opinion is provided, and you decide to go against that legal opinion, you are going to have to give legally sounding reasons as to why you went against a legal opinion that was sourced by you. Most of our institutions got themselves into trouble because they overlooked legal opinions. So if people where they come from, their parties don't work according to legal opinions, but work according to number, it's not our problem. Secondly, to come here and cast aspersion on members of parliament that they are only being allowed to participate because they are white. No one has ever advanced that. And the chair has got a responsibility to defend our members, whether white, female, or male, or black, or anything of that sort. What does the color of the skin have to do with what we're dealing with here? That when people are being witnesses, they are black, but the ones that are questioning them are white. I'm not white, but I'm on the other side of questioning witnesses. If they are white people that you think must be witnesses, you're supposed to submit those white people and argue, and the committee will agree or disagree. But to come here and start creating doubt on us and this committee that we're scared, for some reason we're scared of white people because it is white people that are implicated. We have nothing to do with color here. We deal with what the law says and not emotions. It doesn't matter how much you feel about certain people. Just remain principled. Remain principled and be guided by rules of parliament and be guided by law, not rules of number, 26 or something like that. Please.
But Chair, what is the rules of number?
No, that does not. It is not within what Andile has presented. Andile has presented a legal opinion from Parliament, and the two honourable members who have spoken are right that let's focus on the legal opinion
Chair.
that has been. Hello,
Chair.
Honourable Sauls.
Yes. No, we take note of the indirect comments towards us, but we will not entertain it. What I want to stress is that we have the right to provide our opinion on the opinion. And when we do so, the legal team will then decide whether they want to use our opinion. And if they do think that there's some credence to what we present, and we have convinced them to look at it differently, then they will take such and formulate a different legal opinion with legal backup. And it must be very clear that we are a reputable political party. We have a legal division. We can source a legal opinion. Using my discretion, I'm merely deciding we don't need to go that route. We will just, my input will suffice. I mean, the honorable member should know that we have legal capacity, because one of his members just had to apologize publicly because he received a letter from our legal team. So I'm just saying, we just exercising our right here, Chair, and thank you for protecting that right of expression from our side. Thank you.
Chair, if we are going to allow him to just speak like that and speak like there's no limitation here, we can do the same. He can't claim his party has got some member of another party withdrawing because they've got a sound legal opinion. It remains your party's legal opinion. It is worth the papers written in that office, and they'll never leave that office for anything in society. Our legal opinion is what has been presented by Parliament. And that is what the parliamentary representative told you here, that it doesn't matter, we won't change. Even if you come with that legal opinion of yours, it will not change anything. The parliament has given an opinion, and you say you're going to seek an opinion, you are rejecting parliament opinion. At the same time, I'm going to read this opinion. You are rejecting what you have not read. That's what you are doing, Mus. This mogul, that's how you survive, smuggling people. You don't read. You say you're going to read and then reject after reading.
Let's do
laziness.
Like this,
you can't be part of laziness. Read, man.
Let's do like this, Honorable Malema. The last time you said that the device you were using was not allowing you to raise a hand. And I just want to request that we raise hands and we get recognized by the chair. Look, honorable members, I know that we belong to various political parties. And there is a lot that we can say about our parties here. But I think we have come to the end of this item. What we need to do is that if there are members who wish to make submissions to Andile on the opinion that has been presented here, let's allow them to do so. And the legal team of Parliament will consider those submissions that it would have received. And they will come and give us a feedback how they have interacted with those submissions and how do they clarify them. I think that should be sufficient. I see the hands of Honorable Skosana and Honorable Nomvalo.
Chair, my hand is also up.
I guess, Chair.
Oh.
Good afternoon, Chair.
Yes, switch off your video.
I guess yes, I guess
switch off your video because it affects your sound.
Yes, I guess, Chair, the from Umkondo is your party. I think the honourable member. The issue which the honourable member has raised, if perhaps his party feels strongly about this matter, about this legal opinion as well, but we accept that there's a legal opinion from Parliament, and anyone who's not happy with that, you know the rules. You go to court if you want to. I thank you, Chair.
Honourable Nomvalo.
Yeah, no, thank you, Chair. You would forgive me if I missed something. I forwarded an apology to Ramani. Yeah. I had a radio interview, but I just came in when you were making a summary on this issue, Chair. I think your summary is opening a can of worms, Chairperson. I think in relation to matters of this committee, we must use one legal opinion. or one legal team. And that legal team must be the legal team of Parliament. And once the opinion has been made, we must simply comply. Because, Chairperson, Honorable Ngola can tell you, and other members here who are lawyers or who have a legal experience, that you can call 10 lawyers to come and talk about this matter. Or you can seek legal advices from 10 lawyers. They are not going to give you the same perspective. They will come with different perspectives because they apply their minds differently. There are many ways, there are many interpretations. It doesn't mean that if the law says something, then we can have a similar interpretation towards it. Now, I'm saying, Chairperson, let's have confidence in this legal team of Parliament and say the legal opinion that they have tendered for the committee is supreme. You can take it to your party just to let your party know that this is the current situation on the matter relating to these two members. But to say we will make further submissions, I asked a question earlier that if you say let's make further submissions, for what, Chairperson? Because we will go to our attorney, or to our counsel as the MK party, and the PA, they will go to theirs. We might come with different legal opinions. That means we're going back, Chair. Let's take a position, because the reason why we had this, we resorted to having a legal opinion is because we could not agree. Even now, I can sense that we are not agreeing. So we can't, Chairperson, have an open-ended democracy. At some point, a decision must be taken. And the method that we have used in this regard, I think, is fair enough to say, before we arrive to a decision, let's first get a legal or an expert opinion. So then it means, Chair, if you are subjecting us to what you have suggested, then it means there was no need for consulting with experts. If after the expert has given a perspective, you say members must make submissions again, for what? I think, Chair, let's just close the matter today by saying we accept the legal opinion as is. And I agree with what Honorable Skosana is saying, to say, if you disagree, then go to court. Because we can't stuck around the same issue. At some point, we need to move on. Thank you very much.
I pardon you, because I heard you saying that there is something that you missed, but we will clarify it. Honorable Sauls, and the last will be Honorable Sangon.
Yes, Chair. We will fully use our right to express our view on the legal opinion. I promise that I will submit that tomorrow. But Chair, you are yet to let me know when we would receive a reply, with what would be the turnaround time be for the reply after I submit tomorrow, so that it's not an open-ended, indefinite period whilst the committee continues. So just to have an idea.
Okay.
Yeah. Thank you, Chair.
Honorable Sangoni, Honorable Malema.
Thank you very much, Chairperson. Chairperson, with all due respect, I truly believe that the debate that we're having here is an exercise in futility. When you made your recommendation, which was pointing us in a direction, we agreed as the African National Congress that because despite whatever the issues are, we are not going to take a decision to agree or disagree with the matter without having had an opportunity to go through the documents. So what we understood you to be saying is that here are the legal opinions, they have been presented, the parties must go consider them and then make their inputs. So that's the first point why I think that this is a futile exercise, because we can try and convince each other here, but I don't think that anybody wants to take a decision without having an opportunity to thoroughly apply their minds to the situation. The second issue, Chairperson, which still remains unresolved, and again, why we may be undertaking an exercise in futility, is that regardless of our positions on this matter, at the end of the day, the rules of the National Assembly still do not allow any of us to take a decision with regards to recusal or anything of that kind. So while we may hold very strong views one way or the other, up until that particular situation has been at least decided, then we can discuss these opinions until the cows come home. It's not going to take us anywhere. So I want to propose, Chairperson, in addition to once again reaffirming our support for your proposal, that we have a look at the opinion. I think I align myself with the members that say the DA opinion is a nice to have. It's good to see that the DA has sought an opinion, but it's not binding on the committee. The opinion that we need to look at is the Parliamentary Legal Services opinion, and we're going to have to seek I don't want to call for another opinion again, but we have to answer the question, to what end? Because if we all go through the opinions and we still hold strong positions, there's nothing we can do about it. We can't ask members to leave. There's nothing in the rules that allows us to do that. So that, I think, is a question that we still need answers, Chairperson. And as we go off and look at these issues, perhaps the suggestion that had been made that we get an opinion on that is what we should consider. Thank you very much, Chair.
Honorable Malema.
No, I'm covered, Chair. It's fine.
Thank you so much. Let me tell you, honorable members, this is what is happening. If we were to go out of this meeting now and get to our proceedings, the document which we will use in those proceedings as a document of reference will be the legal opinion that we have here. And the legal opinion from Parliament. And when this matter was presented here, we said our legal team will present the legal opinion, but we will also give DA a chance, because they have circulated their legal opinion with us. But their legal opinion is not for adoption in this meeting. And then, in case there is any member now in this meeting who has issues with the legal opinion that has been raised here, that member will leave this meeting and go and study that legal opinion. And if there are issues that the members want to raise on the legal opinion, they will forward those issues to the legal team of Parliament to say, we have read your legal opinion. There are the following issues that we want to raise with you. And the legal team of Parliament will come back to this committee and said, the legal opinion that has been presented, there are the following matters which have been raised by honorable members. And this is how we are clarifying those matters to you as the legal team of Parliament. And if the clarity is given, the committee can decide if it agrees with those matters or not. But for now, honorable members, we are going to leave with what we have until substantive matters have been raised with the legal team by honorable members. Is that very clear?
Let's proceed, Chair.
I still see two hands, Honorable Sauls and Honorable Nomvalo.
No, Chair, sorry, that's a legacy.
Honorable Nomvalo.
It's a legacy hand, Chair.
Okay.